Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, dan salam kebajikan bagi kita semua. Selamat siang teman-teman semua. Kepada yang terhormat, Bapak Dr. Heribertus Jakatriana, selaku Wakil Dekan Bidang Pengabdian Masyarakat, Sistem Informasi, Fakultas Hukum Universitas Gadjah Mada. Selamat siang Pak Jeto. Kepada yang terhormat, Mas Riko Andi Wibowo, selaku Kepala Departemen Hukum Administrasi Negara. Selamat siang Mas Riko. Kepada yang terhormat, Profesor Christiansen, good afternoon sir. Dan yang terhormat kepada Mas Muhammad Jibril, Mas Ibing, selaku moderator pada acara siang hari ini. Dan kepada teman-teman semua, selamat siang. Sebelum kita memulai acara yang baik pada siang hari ini, izinkan saya selaku MC untuk mengundang Bapak Jeto untuk membuka acara. Kepada Pak Jeto kami persilahkan.
Goedenavond, professor Christensen. Bedankt voor uw komst. We kijken ernaar uit om samen te gaan werken. We hopen dat de samenwerking tussen UGM en Vrije University of Amsterdam mooi kan opleveren. Heel veel succes en tot ziens.
Boleh beri aplaus kepada Pak Jeto. Selanjutnya mohon izin Pak Jeto untuk boleh maju ke depan. Akan ada sedikit penyerahan cendera mata. Oke. Sorry Prof, may you go. Yep. Yep. There's a gift from Law School of Gadjah Mada. Oke. Boleh dokumentasi, silahkan.
Under your personal notes.
I'm flat. You should have done it. It's too much. It's okay, bro. Being here is already. 3, 2, 1, 1 more. 1, 2, 3. Oke, boleh beri aplaus teman-teman. Terima kasih Pak Jito. Thank you Prof. May you. Oke. Boleh beri tepuk tangan sekali lagi teman-teman. Terima kasih. Baik, selanjutnya aku atas nama Pak Jeto juga mohon izin kepada teman-teman semua, kepada Bapak Ibu sekalian bahwasannya ada rapat yang harus dihadiri oleh Bapak Jeto sehingga beliau harus meninggalkan ruangan. Untuk agenda berikutnya langsung saja aku memanggil Mas Ibing selaku moderator dari kegiatan pada hari ini. Kepada Mas Ibing, waktu dan tempat saya persilahkan. Boleh diberi tepuk tangan teman-teman?
Okay, good afternoon everyone. Okay, so today our session is going to be in English, but oh, I'm sorry. Let me introduce myself. My name is Muhammad Jibril, but most of you call me Mas Ibing. Okay, so our today's guest lecture is comparing public contracts in the Netherlands and Indonesia. Judicial and extrajudicial protection, ombudsman for procurement against the government action or decisions. And today we have two speakers. First is Professor Dr. Chris C. Jensen, co-director of the Center for Public Contract Law and Governance at Vrije University Amsterdam. Professor, please do sit in here. Can we give applause for Professor Chris? Okay. The next one is one of our lecturer for our speakers is Dr. Riko Andi Wibowo. our head of the Administrative Law Department of Faculty of Law. Please give applause for Mas Rico. Okay, so today's topic is very interesting. It's public contracts, and for your information, Professor Chris here is from Private Law Department, same as I am, and however, he already worked a lot of things about public contracts, so we can see public contracts in the private law perspective from Prof. Chris, and we are going to see public contracts from the administrative law perspective from Mr. Rico. So, without further ado, maybe we are going to start from the Indonesian first. Yeah. Okay, so Mr. Rico is going to present you his presentation about public contracts in Indonesia. So, the time and place is yours, Mr. Rico.
Good afternoon, everyone. I'd like to warmly welcome you at this seminar or this lecture, whatever it calls. I would like to ask also my colleagues to present my PowerPoint. Yeah, while waiting my presentation, perhaps this is also ada. Bapak yang pindahin atau saya yang pindahin? Oh oke, kalau ada ya manapun oke buat saya. So again, thank you very much, Prof. Chris, for come along. You manage your time to visit us, as well as to share your knowledge to our students in here. I'm great. It is greatly appreciated. Thank you very much. Yeah. Also with Mas Ibing, who help us to become the moderator. As you may already notice that this is an issue that has a dimensions of public and private law. At the beginning, I should admit that shall I collaborate with private law department in order to conduct this event? Yeah, because I don't want to create negative perception that, well, hang on, Rico, what are you doing there? It's something that related to the contract and is supposed to be held by us. Yeah, you know. But then on the other side, this event, I can call it a more spontaneous, yeah, spontaneous race. Yeah? I asked Chris because we were invited to share our expertise to the National Public Procurement Agency in Jakarta, and then I asked Chris, would you also please manage your time if you visit my university and share your talks in there? Because in a way, I always feel guilty, if I may say, if I participate in capacity building in outside the faculty, and then my students do not obtain a sufficient level about that issue. Why I enhance capacity building in outside of my university, while my main obligation is in here. So that's also the reason why I do my best. I'll bet it was a very busy month for me. I push myself to also encourage Prof. Chris to come along from Jakarta to also travel to Yogyakarta and have this kind of meeting. So thank you very much, Chris. Thank you very much, Mas Ibing. So that's the situation there. So I hope I may clarify the impressions, clear impressions about what the intentions of this meeting. My presentation is about public contract law in Indonesia, some unclarities, and the need to address the accountability issue. Next, please. So when I'm talking about public contracts in Indonesia, we have two different terminologies that sometimes use mix up along with the in the practical level. Yeah. The first one is tender, and the second one is auction. Look, public contract. When I'm talking about public contract, it can be meant by contract that at least one of the parties is the public bodies. Yeah. Can be municipalities, it can be ministerial level, it can be non-ministerial level, it can be provincial level, etc., etc. Yeah. So when we're talking about public contracts, at least one of them supposed to be in it is a public body, and therefore it is exercise their action, their power based on public law, particularly administrative law. That's what I'm talking about public contracts. Yeah. And public contracts in Indonesia, we have what's so-called tender, and we also have auction. Kita punya tender atau pengadaan, ya. Sometimes we also call it procurement. Yeah. That's one thing. We also have auction, or in bahasa we call it lelang. Nah, lelang, ya, lelang, lelang. Nah, lelang. Nah, between tender and lelang, and between tender or procurement and auction, sometimes we mix it up, because in the regulation sometimes it is called tender, sometimes it's called pengadaan, sometimes it is called lelang. Yeah. And then I'm trying to figure it out how to make a clear conceptual demarcation between these two. And therefore, I tried to argue that we should use tender terminology when it impacts to government spending. Well, this is the Indonesian perspective, at least my perspective. Yeah? Please, perhaps Netherlands approach or European approach has different with that. Please clarify about that later, Chris. Yeah. So when it impacts to government spending, so then it is better to say it by tender. Yeah. So, for instance, when we build the new building here, building B, yeah, building A, we do not have resources, internal resources to build that, or we do have, but we want someone else who more professional to handle that works. Then it means we conduct procurement goods, procurement services, including construction. Yeah. Yeah, we have Faculty of Engineering, a lot of smart people there, but this is none of their business to make construction works. We have human resources in here, Mas Ibing, yeah, but we have no specialty to make painting, to make the concrete, cement, ya kan? We have no idea about that. So it is better to handle by someone else, company which we hire. That is called procurement goods or services. Sebelumnya Pak. We have also a public-private partnership. We call it kerjasama pemerintah badan usaha. One of the specialties of Mas Ibik. Yeah. So the government invest some of money. Sometimes also they do not invest money, but they give tax incentives. They providing the land, and then the private sectors build the huge constructions, and then afterwards, after it got accomplished, the contractors obtain concession for a long period, 30 years, 40 years, 50 years, yeah. And we as a citizen have to pay some of money when we would like to access that services. Masuk jalan tol, if you come to the toll road, you have to pay. If it is not, if the services related to the basic facilities like health, we do have a hospital, yeah, which is also built by the public-private partnership scheme, and then the government pay it by by having service level agreement. So if the company maintain sufficient services, then the government shall pay regularly, monthly basis or semester basis, etc., etc. Yeah. So in essence, the government have to pay something. That's what I meant by tender. Yeah. So in auction, it occurs when it impacts to government income. So the government obtain money from that kind of activities. So for instance, natural resources concession. Yeah, we find a good oil company extracting on a particular issue. Okay, I grant you the we deal and I grant you the license. We make and then afterwards having a contract, and then along the way the government obtain income. Auction also relevant when we are talking about unlisted state-owned goods. So for instance, after a couple of years, this machine, this computer, for instance, become obsolete. We are no longer use it, and then we would like to sell it. We would like to unregister that from our state goods list, barang milik negara. Okay, barang milik negara. We would like it was listed. You can see the barcode in here. Yeah, every table you see the barcode. It means that it is registered under the state property, yeah. And then after we do not longer use that, we would like to unlist it. It means we would like to sell it. We would like to erase it from our books. We sell it means, well, everyone who are interested to that goods, they can pay. They can submit the bidding process. They can make the auction process. Oke, itu lelang namanya. Nah, lelang. From that kind of activities, the government obtain money, and then that's what I call with auction. We are also using terminology of auction, supposed to be for when when it talks about cooperation with private company to utilize idle state assets. If any land that is registered under the municipalities, public bodies, municipalities, government or ministerial levels, or even state-owned enterprises, and then that land would like to be used by private sector, then they will make a cooperation deal with that, and then they may build an infrastructure, and then there will be some money from the profit. From the profit of making that infrastructure, and we submit it to the government income. One good example perhaps is part of the military area in mana tuh deh, yang di ini deh, Kebumen ya. Saya lupa. Jadi ada daerah di daerah Kebumen, sorry in bahasa, there's an area in Kebumen. They have military fortress in there. It was by the Dutch built, historical parts. And then why don't we access, when a private company approach, why don't we access this and then use it as amusement park, for a recreational park? And then okay, yes, please go ahead. Then between them they make a cooperations to utilize idle assets to become more productive. And then because it involves with the government income, then I classified this under the auction terminology. One should be in mind that people mix it up between tender and auction. Next, please. So the perspective in here is where we have public law and private law. Because of that kind of things. Public law because of administrative law issues. Private law because of we are talking about contract anyway. So there's always two sides of the coin. Next, please. Now, here I would like to emphasize that we do have so many regulations discussing about these issues. Starting from government regulation on utilizing government assets, we also have the presidential regulation or Perpres on public procurement. Currently is being prepared to become a bill, public procurement bill. We have also presidential regulation on public-private partnership. And under that, every single minister have their own detailed regulations, which make more even difficult to understand. So if you are interested on these issues, what we will trying to do our best in the faculty is helping you to see the bigger picture or broader pictures, and you can see from the bird's perspective, eyes perspective, to understand the general context, in order to help you that you will not be lost in the dark. Because if you directly jump in to the particular regulations, it may 100 pages and then you get confused. Yeah. So that's one of the critics mentioning in here. Next, please. It is also important to underline that albeit public procurement has been regarded as the most vulnerable sector in Indonesia in terms of corruption, yeah. Jadi, if you hear any news about corruption, usually it is associated with the public procurement things. Yeah. So perhaps it is important to underline, albeit public procurement has been regarded as the most vulnerable sector in Indonesia in terms of corruption, in fact, the public procurement regulation is the most advanced regulations on the list. And you see on the previous list, it is actually the most advanced regulation in compared to other regulations. Why? Because some other regulations are even not mandating sufficient transparency, and therefore it does not facilitating the market to conduct competition. So sometimes on the regulations, they just say that, okay, just simply approach the public body and then make a deal negotiations. And that kind of negotiations is actually dangerous, creating moral hazard, because it beyond of public scrutiny. Yeah. So what we should do is it should be harmonized in the next level. What I'm trying to do with you, I'm providing the introductory parts, and then please bear in mind, then perhaps if you are interested on this issue, you may come to the private law department. You may also come to the administrative law department, conducting your thesis, the bachelor thesis research. Yeah, we are more than happy to collaborate, and see, at least this is the clue that you may face later on. Okay. Next, please. Oh yeah, this more of the many of the above information are based on the this book. I wrote it with some colleges from administrative law department, competition lawyers, private lawyers. Yeah. Next, please. Yeah. Yeah. As I said, we have too many sectoral regulations. We need so many capacity building needed to understand the regulations because they are scattered. Yeah. To certain extent, too frequent alterations of the regulations. We have so many public institutions with their egos. Okay, I am a Ministry of Homeland Affairs, and I should make clarifications for the provincial levels and mayor and regions to understand what I want by public contracts. And then later on, Ministry of Public Works also issue that kind of regulations, which makes us confused. So people are complaining. People who works in this sector are complaining. So many regulations. Next. Okay, how long still have time, Mas Ibu?
5 minutes.
5 minutes. Okay. So I would like to make it simple. Yeah. So we have complex regulations at the beginning. Now I'm talking about we have problems on the issue of accountability. The problem is we have internal mechanism, yeah, to raise the accountability, to serve the accountability, what so-called administrative justice, seeking justice inside the administration. We have what so-called objection. We have also appeal, ya. Kita katakan sanggah banding, atau keberatan, atau keberatan, terus kemudian banding administrasi. That's what we called, ya. So if your client is not satisfied with the government action or decision, we are doing that mechanism. And afterwards, if it's not working, then you can go to the independent administrative body. However, independent administrative body, which dealing with public contracts, also unclear. We have ombudsman, we have public information commission, we have competition and market authority, the KPPU, yeah. We have many. It is unclear which institution that really has the competence to handle this issue. Every institution looks, well, it seems that it is also parts of my jurisdictions. I will come to that. Yeah. So that's another red flags that you should remind. Next, please. The other red flags is that we did not have, I said did not, I still perhaps do not, have a clear demarcations between administrative court and ordinary court. Because, for instance, let's imagine that an individual, a company feels aggrieved with the government decision, public body decisions, because not awarding the contract to them, to him. Okay? And then afterwards, after he dissatisfied with the internal process mechanism, he would like to submit petition towards the court, seeking the judicial review. The question is, to which court? Shall I go to the ordinary court, or shall I go to the administrative court? I'm going to the ordinary court because, well, it is something that related to the contract. We are approaching to the contract. This is about award decision. And then after award decision, then the next step is making the contract. According to the theoretical foundations, we have what's so-called opposing theory from the Dutch, terminology opposing theory. So every government action that is come to the, that is in a way reaching to the private contractual things, then it's supposed to be seen as a subject of the ordinary court scrutiny. On the one side. On the other side, the administrative court may say that, well, this is an administrative decision. Ini KTUN. This is an administrative decision. Then it is part of administrative court competence. Ya kan? So they are these two court, they are competing each other, and they do not make a clear separations about their authority. Supreme Court fails to make a coherent and consistent approach about this issue. Okay, sometimes the administrative court also say, no, this is not our competence. Please go ahead to the ordinary court. Sometimes the ordinary court justice also say that, no, this is the KTUN, this is the administrative decision. Please go to the administrative court. That happens. So this is the serious handbook. Please allow me 2 to 3 minutes again more, Mas Ibing. Next. So, okay. Fortunately, what I'm trying to do in the last 10 months, I try to advise the government because they are preparing public procurement bill. I'm trying to advise them, look, please focus on these particular issues. Please focus on the court competence issues, legal remedies. Please pay attention on that. And then, at this moment, on the public procurement bill, it is not yet passed on the House of Representatives, but at least on the draft, I can see that they make clarification, clear demarcations. If anything, any dispute before the contract, then it shall go to the administrative court. That's the deal. That's what is stipulated on the draft of the bill. Kalau prosesnya sebelumnya before the contract, then please go to the administrative court. If happens about and if the fuss is about the discussion was about contract and contract performance, then one should go to the ordinary court. That's what is stipulated now. However, it is not 100% accomplish the problems. Next question is, how if a contract, how if a private undertaking, a company, failure in performing the contract? Ya, sudah bikin kontrak janji katanya, so let's say it has to build the construction at the end of the year, it has to be accomplished, but then this company failed to do so. And afterwards, the public body give a sanction. The sanction is administrative sanction, name blacklist. I put you in a blacklist. You know. Saya hukum kamu dengan cara masukkan ke dalam daftar hitam because you are not perform. Yeah. Again, the question is, which competence of the court that should handle the problems? If the dispute arise about the blacklist, whether this shall be handled by the administrative court or again by the ordinary court. On the one hand, administrative court said that it may say that, well, this is administrative decision again, because it is an administrative decision. This is our competence. However, the private lawyers, from the other sides, well, this happens after the competition taking place. This is about the contract performance, the contract performance, and then this, of course, it's part of the ordinary court. So I already predict that the similar mistake, dispute, fuss will reoccur in the future if it is not clarified properly on the bill. Okay, next please. I should be fast. I should also mention the other problems is we have very slow response from the judiciary, so it takes too long to deliver the court ruling. Yeah. It has not been mentioned on the bill. I tried to advise them a couple of times, but they just distracted with the other instructions from the president. Yeah. Next, please. So this was what I talked to them. Please make a clear cut when the problem shall be stopped. So please make sure on preventing the parties to keep going on the court levels. Please be careful by having possibility to appeal and then go to the Supreme Court. You should make a clear cut. Yeah. Otherwise, the contract will not be delivered. The public procurement may not be delivered on time. Yeah. Next, I also mentioned about this one. I will not explain it thoroughly, but because of the time constraint, I'm happy to explain it later. But what I would like to say is that on the bill, it has not mentioned the most important feature that shall be provided, namely effective judicial protection. What's supposed to be embodied on the bill is that if any private contractors, private undertakings feels aggrieved with the government actions and decisions, they should be able to come to the court and then ask the court to provide the protection, instructing the public body to stop the process, public procurement process. And the public procurement process shall not be continued whenever the public body is still make that kind of mistakes. It is not available clearly on the bill. Yeah. I was warned the public body, I was warned LKPP, the National Public Procurement Agency, yeah. If you are not embodying these important features, which is already, I learned this from the AU and the Netherlands and the UK, yeah. If you are not embodying these features, then you will make the same mistake like what happened with the ID card, electronic ID card case. Corruption in electronic ID card case. If you still remember, the case was that yeah, it was supported by the Minister of the Gamawan Fauzi, the Minister of Homeland Affairs at that time. Yeah, if you remember. So the case is there was a competition. Many consortiums participated to submit the bidding for the electronic ID card. Yeah. And then the Ministry of Homeland Affairs decided to award the contract to a particular bidding participant. The other bidding participants felt aggrieved. They submit the objection. Yeah, it's supposed to be stopped, the process tender, because of the objection. However, the ministry said no. I want to proceed the mechanism by hand signing the contract. So it's supposed to be stopped, but he insists, no, I want to continue this process. For what? Because he would like to demotivate the other bidding participants to discontinue the fights in the court, in the KPPU. So if the contract has been concluded, then it has no motivation to fight, ya kan? Make sense nggak? Ya kan? Ya, wah, gimana? Ngapain saya ribut lagi di sini? Ngapain saya ribut di berantem lagi KPPU? Duitnya udah diambil sama kontraktor yang lain, udah tanda tangan. The contract has been concluded. And then so it demotivate them. And 1 and 2 years after, we heard that the contract has been tainted by corruption. Well, we already heard at that time, we already suspicious, but then the judicial system just doesn't have this mechanism. That's the problem. So we have a problem on preventive measures to prevent bad things happens, and then we are really focusing on, okay, we are arresting these people, etc., etc. Preventing mechanism has been not really paid attention by the government. I think that's the next slide. I think that's the last slide that I have. Yeah, so if you are interested with the bill, to see the further critics that I've made, you can access these literatures freely on the internet. Yeah. So one from the University of Airlangga I published just recently. This 1 or 2 days ago it was released. Yeah. And the other one last month, from the Transparency International Indonesia. Yeah, I think that's all. Thank you very much for your kind attention. Mas Ibing.
Okay, applause for Mr. Rico. Okay, thank you so much, Mas Rico, for the presentation. I found some of the topic very interesting. Moreover, the capacity building one, because before I work here, I work in Indonesia Infrastructure Guarantee Fund, PT Penjamin Infrastruktur Indonesia, and one of the tasks is to build the capacity of the people in daerah, in the province, because there are so a lot of regulation and not a lot of people understand it, and they are afraid to go to KPBU or to the public-private partnership. Okay, so to minimize our time, next I'm going to give the microphone to Professor Chris to tell us about the public contracts in Netherlands. The time is yours.
Thank you very much. Thank you very much, you all, for for receiving me in the way you have received me at this faculty. I'm very honored to be here. This is my first time in Indonesia. At school in the Netherlands, we learn a lot about Indonesia. I read as a child and also as an adult, I read a lot of books about Indonesia. but I never dreamt that I would go actually to the country. So finally a dream has come true that I can visit your great nation, and I'm quite sure it won't be the last time that I've been here, because I'm really looking forward to cooperate with UGM in general and Dr. Rico in particular. I'm also very much looking forward to discuss with you the topic of today, public contracts. I am, as already has been explained, I am a private lawyer. I was raised as a private lawyer. I have a chair in Amsterdam at the Vrije University on contract law. I teach contract law, I teach construction contracts, but I also teach public procurement law, because in the Netherlands, the public procurement law area is completely within the domain of private law. I'm going to explain to you why that is and how we dealt with some of the problems that Dr. Rico has already talked about from the Indonesian perspective. So, could I see the next slide, please? First of all, something about the concept of public contracts. In the Netherlands, we regard a public contract, any contract where a public body is a party to. So, and with the concept of public body, I mean that these could either be bodies of the central government, like the state of the Netherlands, or one of the ministries of the state of the Netherlands. On the other hand, we also make a distinction between all kinds of local governments, like provinces or municipalities, public agencies. So whenever such public bodies conclude a contract, we call that a public contract. So this is to start from. Now I'm going to show you some examples of types of public contracts we distinguish in the Netherlands. Could I see the next slide, please? So first of all, we have what we call public power contracts. Public power contracts are contracts where a public body agrees with a private party how the government will use its public power. So, you could think of contracts concluded between a local municipality and a project developer, where the project developer needs licenses under planning law, and in that case, a contract is being concluded between the project developer and the local government, how the government will use its public power. Because issuing licenses, and the same goes for providing subsidies or other public power actions, is obviously an authority which only public bodies can exercise. So this is also the reason why public power contracts are contracts that can only be concluded by public bodies on one hand and private entities on the other hand. I'm not going to say any more about public power contracts, but I'm going to say a lot about the second category of public contracts, which are what we call public contracts of a private nature. Here we talk about contracts that can also be concluded between you and me as private citizens. We can enter into a contract one another in order to sell goods or to supply services or contracts for lease. These are contracts that can usually also be concluded between private persons. However, when one of the parties to the contract is a public body, we call such contracts public contracts of a private nature, or also known in the Netherlands as private government contracts. There are also examples which are actually a mixture between the two. That's also possible, but in generally the distinction is actually between the real public power contracts, which only the government can conclude, and the public contracts of a private nature. Yes, so I will focus on that second category, public contracts of a private nature. Next slide, please. And within the domain of public contracts of a private nature, we can discern the so-called public procurement contracts. Again, contracts of a private nature, but these are contracts where the public body buys goods and services on the market. Procure, as the posh English word is usually used. And obviously, the public bodies, when they procure goods and services on the market, they will don't do that for themselves. They will do that for their citizens, the public at large. And these goods and services are, as we all know, being paid by taxpayers' money. So the public bodies are spending actually the money of the citizens. Just to give you some figures, in the Netherlands, almost 20% of the gross national income of the Netherlands is being produced by public procurement, governments buying stuff from the market. So that's one comment on public procurement contracts in general. Secondly, please the previous slide. Yes, thank you. It is an ordinary contract. So what we teach our students in Europe is usually the distinction between the pre-contractual stage and the contract stage, and it won't be different here either, I presume. So, as any other contract, public procurement contracts also consist of these two stages. So I would now like to show you something about what is the substantial law that is applicable to these two stages, and where does the particular position of the government have a place? Because, as I said, these are contracts of a private nature. So what does that mean for the substantive law? Next slide, please. As you can see, both the pre-contractual stage as well as the contract stage, it is the rules of our Dutch civil code that apply to these stages. Because the government, when procuring goods and stuff on the market, is acting as private parties could also act. So we don't need any specific rules for the government, because when I buy goods on the market, I conclude a contract. That's not different from the government buying stuff from the market. They also conclude a contract. So they can work with the same rules, and that is exactly what's going on in the Netherlands. Nevertheless, we cannot ignore, of course, that it is the government who is buying stuff on the market. And the government, as we all know, has a particular position within society in general and within the legal framework in particular. And this is why we have a rule in our civil code that explains something about how governments, when they use public-private contracts, how they should act. They will not only be subject to the rules of the civil code, no, they also have an additional duty to perform their acts under the civil code, taking into account the acts of parliament and all sorts of written and unwritten principles of proper administration. So we could say that the public capacity of the government gives a specific touch to the application of the general rules of the civil code. And this is important. So that means that whenever we have to deal with issues, contractual law issues involving the government, we will apply the general rules of contract law, but we always have a look at the particular position of the government, and what does that particular position mean for the way in which we apply the rules of the civil code. Next slide, please. Now, one of these acts of parliament that should be obeyed by our government is our Public Procurement Act. And as you can see, it has a very important role in the pre-contractual stage. During the pre-contractual stage, the government, when buying goods and services on the market, will have to observe the civil code rules, but also the rules from the Public Procurement Act. And these rules curtail the discretion of public bodies buying goods and services on the market. Next slide, please. This is the reason why we have a Public Procurement Act in the Netherlands. This is Europe, as you can see. Most people don't know that this continent, which we call Europe, is much smaller than the great nation of Indonesia. If I tell this to my children, they say, I'm going to Indonesia. So how big is it? And I say, well, it's much bigger than Europe. But this is Europe, as you can see. Europe is the reason why we have a Public Procurement Act in the Netherlands. The European Union, as you may know, has been established in order to secure that we have an internal economic market in Europe. So every country in Europe must open its markets for companies from other countries. So in the Netherlands, we can no longer say German or French companies are not allowed to enter our market. All companies from Europe are free to trade with us, and vice versa, of course. So that is the reason why we have a Public Procurement Act. Next slide, please, and I can show you this. So the objective of Europe, of the European Union, is the creation of a single market for public contracts. Public contracts should be entered into freely without borders. So no country in Europe can say, we only buy national products. That's not allowed. The instrument we use to create this internal market is the instrument of tendering, the instrument of compulsory competitive tendering. Whenever our state or provinces or municipalities want to buy goods on the market, they will have to do so by organizing competition. So they must allow all market parties that are interested in the contract, they must obtain, they give them the opportunity to obtain the contract, provided that the amount, the financial value of the contract is sufficient to attract the interest of companies from Germany and France, etc. Okay, next slide, please. So, although the objective of our legal framework is this creation of the internal market, competitive tendering serves a lot of other public interests. Could we see the previous slide, please? Because now we're missing something. No, we don't. So the objective is the creation of a single market, and we do so by competitive tendering. And when we apply the instrument of competitive tendering, it means that our public bodies are under a duty, a stringent duty, that they may not discriminate on grounds of nationality. So they cannot say, you're a German company, so stay away from my market. All companies need to be treated equally. So all companies have to have an equal opportunity to obtain the contract. That means that our governments, when they buy stuff from the market, need to be transparent. They have to explain in advance what they want and how they're going to decide. They have to decide according to what they have explained, and afterwards have to show how they have decided, be transparent, in order to allow the companies to check their actions, and in order to allow the companies to check whether all companies indeed receive this equal treatment. So actually the transparency principles is actually the motor of the principles of procurement law. And last but not least, we have the principle of proportionality that needs to be observed. So these are the important principles of public procurement law, taken into account when competitive tendering is used, and the objective is the creation of an internal market. Now the next slide, please, because this is what I wanted to say previously. Using these instruments of competitive tendering and following these principles does not only assure that we create the internal market, but it also takes care of a lot of other interests, some of which are even in the Public Procurement Act. We have a rule in our Public Procurement Act that says if the government buys goods from the market, it shall do so in a way that creates value for the taxpayers' money. Because it's our money that the government is spending, so they should do it wisely. We have a rule in our act that says if the government spends money and buys goods and services on the market, they should endeavor to seduce the companies in the market to come up with innovative ideas, new products, which we need for the green economy, new products and processes and techniques which we knew in order to combat the climate change and the consequences. So we also have a rule that says, thou shalt procure in a sustainable manner, create jobs if possible, fair wages, take into account labor stats, be assured that in the production process, in the supply chain, human rights are being observed. Budget control is, of course, a very important objective that can be served if governments apply the principles that you saw on the previous slide. And some other objectives, last but not least, of course, because we have corruption in the Netherlands as well. Corruption is an international phenomenon. But if you apply the system of competitive tendering, and if you impose a duty upon governments to follow these principles of procurement law, equal treatment, etc., transparency, that can have a very good preventive function in combating corruption is our experience. Next slide, please. So, public bodies must do this. They must follow these principles. What happens if they don't? What happens if a public body decides, I'm not going to treat people equal, I'm not going to be transparent, I'm just going to discriminate them and treat them unequal? What is then the legal protection offered by the legal system? Next slide, please. So, in the contract stage, we only have the judicial review by the civil court. So if the contract is concluded and the contract is being performed and something goes wrong in the course of the execution of the contract and either party wants to go to court, you have to go to the civil court. The same goes with conflicts and disputes that arise in the pre-contractual stage. You also have to go to the civil court, even when there is a violation of one of these principles of procurement law, which can be derived from the Public Procurement Act. And we have a secondary option, and that is that you can ask for judicial review by the Public Procurement Ombudsman. We have that Ombudsman now for 10 years, and I will, at the end of my presentation, I will say something about the Ombudsman. First, I want to focus on judicial review by the civil courts in the pre-contractual stage, because that's my focus. I think that's on the next slide as well. Yes, so we're going to focus on the pre-contractual stage. Next slide, please. So judicial review by the civil courts, when a company thinks, I have not been treated fairly, I did not receive an equal opportunity to obtain the contract, the public body violated the principles of public procurement law. The usual road is that you go to the civil court and that you ask in a summary procedure for interim measures. That's the first step. And then the court is asked, please court, could you establish that this public body violated the principles of public procurement law? And if so, could you then please suspend the public procurement procedure, even revise the procedure, etc., etc., and in any event, prohibit the public body from actually concluding a contract. We first want to solve things because something went wrong. So that's what the usual legal proceedings are. What also is possible is that proceedings take place on the merits of the case. Particularly when a public body concludes a contract, procurement contract, without competition, so just direct contracting without publishing contract, without competitive tendering, then you can have the contract be annulled by the court in the proceedings on the merits of the case. And next, it's possible, but it's very theoretical, that a company who is disappointed about the behavior does not go for the first procedure, but goes instantly for a merits on the case procedure and only asks for damages. That's also, but it's very theoretical, so we can skip that. Next slide, please. So this is the main rule that companies disappointed go to the ordinary courts and ask for interim measures in summary procedure. Explain a little bit how that works and what is happening just prior to claims that are being forwarded in a summary procedure. Next slide, please. So the problem starts somewhere in the competitive tendering procedure. And the competitive tendering procedure will usually end with what is on the top of the slide with an award decision. So the public body will say, I have compared all the bids of all the companies, and this entity, this company is the winner of the procedure. So I will award the contract to that bidder. It's only an award decision, not conclusion of the contract yet in the private law way. It's the decision, I will award the contract to you, but now I have to wait for 20 days because maybe someone is really frustrated about the fact that I gave you that I'm going to contract with you, so we should allow the other competitors, number 2 and number 3, etc., to come forward with their claims. And they can come up with legal proceedings from the very beginning of the competitive tendering procedure until the conclusion of the contract. That's the main rule. And suppliers who want to come up with proceedings, they have to do it pretty fast, because if they see that the government has made a mistake in the procedure, they must not wait too long, because otherwise they will have waived their right. So they get a reasonable time, but they must not wait too long. So let's assume that a company indeed is in time with its claim, and that interim measures are being claimed for within this period of 20 days after the award decisions. In that case, when the case becomes before the court, the public body may not continue, they may not conclude the contract, even when the 20 days have passed. Asking the court to come up with an interim measure means that the tendering procedure is suspended. So parties will have to wait for the decision of the court. So what decisions can the court give then? Next slide, please. The court could rule against the supplier, and the court could say, I've looked at the case, and this public body has done its homework, and the decision has been taken properly in accordance with the principles of public procurement law. In that case, the public body can continue, can conclude the contract, etc. And it also means that the disappointed bidder has no longer any actions available. So appeal is not possible. That is when the court rules against the supplier. If the court rules against the public body, stating this public body has violated the principles of public procurement law, then there's a ban on concluding the contract. So in that case, the public body must act in accordance with the interim measures of the court. On the other hand, the public body will then have the opportunity to appeal against the decision, because they need the services and the goods, so they want to continue with the process, but they can only continue if a higher court has dealt with the issue. So next slide. There's one thing we are thinking about now changing. We feel a bit sorry for suppliers who get their case denied, and if it's clearly obvious that the court at first instance made a mistake. Because that's possible. Courts consist of people, and people make mistakes. So we're considering now, would there be an option in really stressed cases where really something went wrong to allow the supplier to appeal, given the fact that a clear wrong decision was taken by the court of first instance. So the Ministry of Economic Affairs, I'm advising them in this context, is considering to change the law in this domain. So that's one point. Next slide, please. That brings me, so this was the legal protection at the ordinary courts. Now something about the Public Procurement Ombudsman. This is a body that exists now for 10 years. I was involved in establishing the Public Procurement Ombudsman, and in the last years I was the chairman of the Public Procurement Ombudsman. I retired 2 years ago because I wanted to spend more time on academic work, so I quit. I think we dealt with, in my time as a chairman, with about 650 complaints, all from companies who went through the PPO in order to file complaints. We have this ombudsman because companies find it very difficult to use the ordinary court procedure. Litigation in the Netherlands is very costly, particularly for small and medium enterprises. They have to pay a lot of money, and the chances of winning the case are not very high, because it's a competition procedure. So what they needed was an entity with lower standards to go to, with easy access in order to file complaints. And that's why under the Dutch Public Procurement Act, the entity of the Public Procurement Ombudsman was created in 2013. And you can see what its objectives are, but the main thing the PPO does is they deal with complaints from market parties who feel treated unfairly by the government. And the duty of the PPO is that they have to deal with such a complaint, and in the event he will have to give a legal opinion on the complaint, which is then a non-binding legal opinion. We'll say a few words on that later on, because they're slightly considering changing the system right now after 10 years. Next slides, please. Yes. So what is a complaint? This is an English translation of the Dutch wording in the regulations of the Public Procurement Ombudsman. You can see who can complain. So any supplier who was interested in obtaining the contract can file a complaint. But also, if individual suppliers are afraid to issue a complaint against the government, because that happens in the Netherlands, we have a saying which goes in English like, "Don't bite the hand that feeds you." So some of our companies find it very difficult to openly oppose the government. In that case, they can ask the industry organization where they are a member from to move forward and to file a complaint. So I dealt as a chairman of the PPO with lots of complaints from industry organizations. It's very easy to file a complaint. You don't have to be a lawyer. You don't need legal advice. You explain in your own words in a simple form, I was participating in that competitive tendering procedure. That was going on, and suddenly I received a letter stating that I was kicked out of the procedure because I didn't qualify, or that my bid was not in accordance with the technical specifications, or that I had a good bid but someone else was better. I don't believe it. I think I have a better bid than my competitor. You can write that down in layman's words. You don't have to find a legal provision in the Act in order to underpin your claim, and the Ombudsman will interpret the documents and deal with the complaint. Next slide, please. They're considering in the Netherlands to make this not to expand, but to make smaller the competence of the PPO. And now the PPO can deal with complaints on any decision taken in the public procurement process. So this means both decisions on the preparation of the public procurement process and the implementation of the procurement process. And we are considering in the Netherlands to give the PPO a specific function at the very early stage of the procurement process, when a lot of important decisions are taken by the government, because these are the typical decisions that hardly become before the ordinary court. So we think that the PPO could have a valuable complementary function, particularly at the very beginning of the tendering process. But perhaps this is too technical, but I just wanted to mention that the law is probably going to change on this. Next slide, please. It's possible that the Ombudsman will say, we're not going to deal with the complaint. One reason is you cannot go directly to the PPO if you have not first discussed things with the public body itself. So you should first deal with the complaint with the public body. And if the public body doesn't help you, well, then you can move up to a next level, to the PPO. So that's possible. It's also not possible to deal with a complaint if the supplier who is not satisfied takes two options at the same time, filing a complaint with the PPO and filing a lawsuit with the in summary proceedings. You cannot have it both ways. So in that case, the PPO will say, well, you went to court, it's out of our hands, let the court decide, and we will not deal with the complaint. When the PPO deals with the complaint, it will ask the public body, here you have in layman's terms the complaint from the supplier. Could you please respond to that? And the PPO will ask the public body, whilst dealing with this complaint, would you be so kind as to stop the tendering procedure? Mark my words, would you be so kind as to stop the procedure? So the PPO has no authority to say you must stop. They do not have the authority, but they can kindly ask. And professional public bodies tend to follow the authority of the PPO. And they tend to say, okay, it's for the greater good. I'm a public body. I have to have my responsibilities against the public at large. I will do as you ask me. And in cases where the public body is not willing to do so, then the ombudsman will tell the supplier, hang on, you filed a complaint, but the public body is not stopping the procedure. So we will deal with your complaint, but maybe they start continuing with the procedure and eventually conclude a contract with the winning bidder. If you want to prevent that, go to court. Because if you go to court, court will help you stopping the tendering procedure. And in the end, the ombudsman will then analyze the complaint, come up with an opinion, and these opinions of the PPO, they read like the verdict of a civil court. So it's a thorough analysis on the facts of the case, testing the facts of the case within the framework of the Public Procurement Act, and at the end of the verdict, because it isn't a verdict, of course, it's a legal opinion, it says, we agree with the company who filed the complaint, or we disagree with the company who filed the complaint. I still say we because I feel still very connected to the PPO, but if the PPO comes to the opinion that the company is in its right, that the company indeed correctly filed this complaint and that the public body was wrong, what could happen is that the company takes the legal opinion of the Public Procurement Ombudsman and goes to court and files the opinion of the Public Procurement Ombudsman as an expert opinion, which helps the court to rule, to come up with a ruling in court. In doing all this, the people from the PPO, so there are three. The ombudsman consists of 3 people when they analyze cases with the help of a secretariat. But there are 3 members within the commission, a chairman and 2 other persons. But what the PPO can do is ask from its own experts in the organization additional information to help them to come with this non-binding opinion, because it's a non-binding opinion. The public body can say, well, thank you for your thorough analysis, but I still think I'm in my right. I will move aside your legal opinion and I will continue with the process and conclude the contract with the winning bidder. That's out of the hands of the PPO. In that case, it's the supplier who will then have to decide, I take you to court. That's one part of the story. The other part of the story is that many professional public bodies acknowledge the authority of the Public Procurement Ombudsman, and even though the opinion expressed by the PPO is a non-binding opinion, they sometimes accept it and follow the non-binding legal opinion of the PPO. Final slide, almost final slide. What's going to change? They are considering to change the situations where the ombudsman can refuse to deal with the complaint. This has to do with the following. There's no duty yet for suppliers, when they want to complain, to go to the government itself first. And there's no duty of the government to have internal complaints officers. And they're changing the law right now that every public body is under a duty to establish its own complaints desk for public procurement. And it will then be a duty for companies first to address that complaints body within the organization of the public body before you can file a complaint at the PPO. That is one. Secondly, and then I conclude, it has been said after 10 years that the ombudsman on public procurement in the Netherlands is what they call a tiger without teeth. I don't know if you know that expression, a tiger without teeth, because they cannot suspend the procedure and their opinions are non-binding. So what they're considering to change now is they do not want to make the opinions binding. That's what politics do not want. But what they do want is to give the public procurement ombudsman power to suspend the tendering procedure. And that would be a game changer, of course. It will probably also attract a lot of complaints from the market because they know that's our instrument, actually, to suspend the procedure. It's not being enacted yet, but it is the way that they are considering now to move forward. Good. Thank you for your attention. Thank you.
Thank you very much, Professor Chris. It is a very comprehensive information about public contracts in Netherlands, and it is interesting when we discuss what is public body in Netherlands, as we discussed before. Okay, without any further ado, I'll be opening for the first term of the question. And for your information, kalau mau tanya pakai bahasa Indonesia, it's okay, and I'm going to translate your question towards Chris. Jadi boleh tanya pakai bahasa Indonesia. Okay, for the first term, I will give to two persons to ask. Okay.
Check. Okay, thank you. My name is Anggun Firmansyah from Construction Project Management in Faculty of Engineering. For Mr. Rico, my question is, in a government construction project, those who typical draft contract are often not expert in law and engineering. Sometimes, employees with minimal knowledge will mostly copy and paste from template. What are the best effort to improve a bureaucracy system like this? Yes. For Mr. Chris, is corruption as a common in the Netherlands as in Indonesia, especially due to the lack of understanding among contractor, architect, and owners about construction contract? Thank you for my question.
Okay, thank you, Mr. Anggun. And the second question?
Thank you. Let me introduce myself. My name is Didi Heranto Mahendra. I am a civil engineer master student at Gajah Mada University. This is my question is for Professor Jensen. Okay, my question is, I want to ask about agreement and contract. This elementary question. In construction, literally all agreement in construction are known as a contract. My question is whether in Indonesia or in the Netherlands, there are different definitions between agreement and contracts. Because, as we know, in Indonesia, this difference is regulated in law. So, is it the same in the Netherlands? Thank you.
Okay, thank you, Billy? Dili.
Didi.
Oh, Didi. Okay, thank you, Mas Didi. Okay, I'm going to cover for the first two questions. Maybe the first question from Mas Anggun towards Mas Rico. The question is about not all of our people is an expert in contract. So the first question is, what is the best effort to improve maybe the capacity building as discussed before. Okay.
Okay, so do I understand it correctly that both of you are from Faculty of Engineering? Yes. So how many from the Faculty of Engineering? Okay, most of, oh, amazing. You too? Oh my God. So, so we will meet next at the end of this year, eh? Because I will teaching you in there. Oh, I also sent an invitation letter to the my students at the Faculty of Engineering. I haven't met them yet, so I was invited. I'm invited to the faculty.
Well, you can see how popular you are.
Yeah. So it seems that almost 50-50. Only half of my students from Faculty of Law is here. Okay, welcome to the Faculty of Law. Thank you very much for coming along the way. Yes, Mas siapa tadi? Mas Anggun ya? Mas Anggun. So Mas Anggun, that's true. I think it is always good, I think, to be honest with ourselves and then to take a fundamental approach to address the problems. To a certain extent, when I'm discussing with public bodies, bureaucrats, they would like to have a shortcut solutions. It seems that everyone would like to have shortcut solutions. I just talked to Chris this morning, for instance, about our weather in here, whether we have a dry season or a rainy season. Yeah? I'm saying, I told him that actually we're supposed to have rain season now, but we are in the dry season. It looks like we're still in the dry season. I told him that many of our dams are drying, right? And then I further informed him that, so what is the point of having many large infrastructure, particularly dam, if we have no water in it? What we need to do is planting more plantations, yeah, in order to secure and produce the water. That's the first step that we should have, and afterwards we need to build the dam. Make it in sequence. What happens and how the policy is taken in Indonesia today is that making the dam first and then cutting the trees. That's what happens now. You get my point? So that's that. We call it in public policy context. It is allowed in public policy context. It is called as fallacy of thinking. Sesat pikir. So right now I'm coming to your point. Yeah. We should, if we would like to, we would like to honest about ourselves. Why many contractors confused or many private undertakings confused with when reading the government contract, draft of the contract that is prepared by the public procurement officers before the contract. It is also embedded with our culture. Our culture, we as a Malayu people, yeah, we love to speak. We are lazy and we are not trained to write. We may spend a lot of time to chat, have a chit chat, yeah? But we are not really advanced on writing. So, the most important thing to do, basic fundamental things to do for the government should not jumping directly to the capacity building related to the public procurement. No. The most important thing is that how to transform from the ideas into writing process. That's the basic things that should be trained to the implementators. That's number one. Number two, that's a bit cultural answer. Yeah? legal culture and so on. Now I'm coming to the more substantive administrative law approach perspective. If the draft contract that is supposed to be provided before the tender process is not clear, then the bidding participants and potential bidding participants should be able to seek clarification. According to the current regulations, presidential regulation right now, the potential bidding participants do not have legal standing to seek clarification. Nggak punya dia. Maksud lu tuh apa sih? Gitu. Nggak punya dia. That rights it's only belong to the bidding participants. So after they are submitting their documents, after having competitions, then they have legal standing to seek clarifications. It is already too late. Ya, nangkep ya konteksnya ya, gitu. Too late. Gitu. So legal standing shall be given by the regulations at the very beginning phase. Yeah. Next point is, to certain extent, and I met many public procurement officers, they consider themselves have conducted or adhering principle of transparency because of they are already uploading the documents on the system. I told them that's not transparency. It is not transparent. It is not transparent enough. Transparent shall be meant if the document can be understood in the same way between you as a public body or public officers with the potential bidding participants. That is called transparent. Please revise me later on, Chris. If I understand it correctly, in European perspective, it is called as reasonably diligent tenderer. Ya, jadi it has to be understood, bisa dipahami oleh orang dengan kecerdasan yang rata-rata. Ini dokumen ini harus bisa dimaknai sama orang dengan kecerdasan yang rata-rata. Nangkep nih gitu. Oh, maksud lu pasti gini kan gitu. Nah, itu enggak. So, we have a cultural issues, we have a legal standing problems. We also have a clearer guidance on how should we interpret by transparency means. I think those three that I can comment with. Thank you.
Okay, thank you so much, Mas Riko. Maybe we're going to move to the second question from Mas Anggun to Professor Chris about how common is it corruption in the Netherlands, maybe in particular in the context of procurement. And maybe I'm going to add a little bit of this because just I think 2 weeks ago, I gave a training towards the state-owned electricity company on their inspector, and they also said that oftentimes, for example, the contract should be 3 diameters, the cables, but in practice it's only 2 diameters. So it's pretty common, maybe in Indonesia, and maybe how about in the Netherlands?
Thank you for your question. I hesitate to make a comparison between Indonesia and the Netherlands because I'm not an expert on the situation. That having said, I know that Dr. Rico can probably produce diagrams that show the development of corrupt behavior between various parts of the world. And it looks as if from these diagrams that the OECD countries, it's pretty much okay. But these are the diagrams. If I look to I can say something about the Dutch situation, okay? Dutch people like to cheat as well and to play games. So they like to mislead the tax office. They like to cheat insurance companies. They probably also like to make deals that actually shouldn't be made in order to get profits. That's something Dutch do. for instance, we've had a large, very large construction cartel in the Netherlands that was discovered in 22 years ago, which led to parliamentary inquiry. All the firms in construction in the Netherlands made deals among themselves. Any new public contract that was put on the market, the companies talked to one another and they said, this time it's your turn to get the contract, and this time it's your turn to get the contract. It was a very sophisticated system. This was in the 20th century, you know, and it was common culture. So I don't believe, but this is my personal view, that people in one country are better or worse than in another country. I think all people try to do good and have their sins. The question is, how do you control sinful behavior, if I may say so? And that's what we tried when it comes to corruption and preventing corruption within public procurement. We opted for the preventive measures, in the sense that we try to organize the process in such a way that every actor who takes decisions in that process and could be seduced to sinful behavior is controlled. So we've got a lot of control mechanisms. Public bodies, people working within public bodies are not allowed to take their own decisions. They can take their own decisions, but we always act under accordance of the 4 eyes principle. There are always other people controlling one another to be sure that decisions in the procurement process are taken in accordance with the law. So it's the problem is not good people, bad people. The problem is good governance and bad governance. Maybe this was too sophisticated answer, but this is how I feel about it. And maybe the question from
Didi.
From Didi, yeah.
Yeah, it's about is there any
Oh.
Okay, it's okay. The question is whether there is a distinctive difference between agreement and contract in. Maybe it's just a nomenclature, right? But whether there's a distinctive difference between agreement and contract in the Netherlands.
The difference between the contract and
Agreement.
Agreement.
Yeah.
I think it's a matter of wording, because we use when we as scholars write about contract law issues, we use the 2 words. Yeah. That's what we do. So my answer would be very short. No, there's no difference.
Okay. May I add to this? Okay, yeah. It's okay because I'm a private lecturer in here, so I want to give enlightenment. So yeah, in Indonesia, it's also interchangeably. Although oftentimes people misinterpret that contract is something that is formed, tertulis, or and agreement is any agreement. But in Indonesia, it is also interchangeably used.
Yeah, from that perspective, you could say in order for a contract to be valid, you need the meeting of minds of the 2 people, and this meeting of minds we would call there's an agreement. But having said that, we still would say they are interchangeably used. Yeah.
Okay, thank you so much, Mas Rico and Professor Chris. Maybe we are going to move to the last term or the second term for the question, and I will going to give 2 people that is want to ask. Anyone? Yeah. Oh, you too. I didn't see her. Oh.
Thank you very much. My name is Najida. I'm from Mula Warman University. Prof. Chris, I want What do you think about the how much can be effective about a blacklist for contract who make a cheat contract? We have maybe compliant with ombudsman maybe, and then with in case in private law we have a notaries association. We have maybe blacklist someone who person or maybe rare person who make a cheat from that contract. How in the Netherlands it is effective for give maybe a deterrent effect like that?
Okay, thank you so much, Miss Najidah.
Yes.
Okay. Okay. One more question. The last question. Okay.
My name is Made from Faculty of Law. I would like to ask from Professor Chris about like how the citizen can file a complaint about the environmental complaint or maybe the public service complaint to the in the Netherlands to the ombudsman itself. That's it.
Okay, thank you, Mbak Made. Okay, I'm going to move to the first question from Mr. Jida. How effective is blacklist in Netherlands? Maybe if I were to elaborate on that question, maybe okay, we can blacklist one legal entity, one company, but they may make another company under different name, right? So is blacklist effective?
May I also ask?
Yeah. Okay.
So, Chris, Indonesia is rely on state-owned enterprises, and for making involved in the economic activity. But then after many years of independence, we or the government remains to give a strong access to the state-owned enterprises. Perhaps the most infrastructure projects in Indonesia carried out by these SOEs. Yeah. To a certain extent, they are good, but sometimes we also can see they're involved in corruption activities. And then it comes to the discussion when we would like to give administrative sanctions like blacklist. They are too big to be blacklist because they are so huge, yeah, too big to be blacklist. If we blacklist, it will be only few of the construction company which is really good on the market, and it gives also a dilemma on our situation. So from the construction faculty of engineering, they realize about this issue as well. My question is whether you realize or heard about the same situation will also happens in Netherlands or in any country in Europe that you're familiar with, and how to deal with that issue. Thank you very much.
Thank you for your question. As I understand the context correctly, these SOEs are actually the companies who provide the goods and the services to the government. So the SOEs are not the entities who require goods and services, no, they supply them to the government. Both, okay, they can do both, yeah.
So we have, for instance, we have state-owned enterprises for water management, providing water on behalf of the government, so as the arm's length of the government.
Yep.
But we also have like state-owned enterprises, which has nothing to do with the public needs. For instance, on the hotel sector, there is state-owned enterprises on hotel and leisure activities. There is also state-owned enterprises working at the constructions, like I mentioned earlier. So they are providing services to the government, and at the same time, the government may also instruct them to do building the toll road, etc., etc.
Yeah, this is. Well, I think this is an important distinction with the Netherlands, and I think also within Europe. But I'm not an expert on that, but particularly in the Netherlands. First of all, a state-owned company in the Netherlands and also in the rest of Europe, when it comes to procurement, they have to follow the same procurement rules as the ordinary state. So the state-owned companies provided, of course, that the state has a dominant influence in the company. Then the state-owned companies, when they want to buy goods and services on the market, have to follow the Public Procurement Act. That's one. Secondly, state-owned companies who engage in economic activities that have nothing to do with the public interest, I'm not familiar with that in the Netherlands. So we do not have construction firms, for instance, who carry out construction activities and who are partly, even a tiny bit, owned by the state, because the state will say, that's the market. The market can what the market cannot do is doing the things that are typical for the government. But ordinary things that are already provided by the market itself, that's not something where the state should be involved. So we do not have state construction firms or hotel chains that are being exploited by companies that are partly owned by the government. So this is not a legal difference. This is just a difference in fact. So then it is very difficult to answer your question from a legal perspective. I could say something about how we deal with blacklisting in general, in order just to prevent indeed people who are on some kind of a blacklist cannot move any further. This is how we do it. If our government buys goods and services on the market, and if a company wants to participate in the tendering procedure, they can only do a bid when they also produce a declaration of good behavior of the company. And you have to ask a declaration of good behavior at national institutes like, for instance, the police. They will check the company and they will check the important people working in the company, and you will not get this declaration if somebody is working in the middle level or high level of your company who has been convicted for crimes in the past. So even if that person would say, well, I start with a new company, it's the same, because again, the company will be scrutinized by the police and they will say, there's someone in your company working who has been convicted for crimes in the past. So that means you do not get the declaration of good behavior. That means you do not get a public contract. That means you cannot survive. And the only thing to survive is to kick out the people on your pay list that have been involved in criminal activities in the past. So it's a cleansing system. They try to root out in this way the people who are involved in crimes. That's one part of the solution. The other part of the solution is that a company as such can have a conviction in the past for criminal activities, particularly bribery or other corruption forms. If that is the case, and a court of law, a criminal court of law, has actually given sentence that this company was involved in bribery in the past, that means that that company, if it tries to participate in the public procurement process, it will be excluded for a period of a couple of years, so they cannot take part in the procedure. There's one exception, and that is if the company can show, sorry, we did a lot of wrong, but we tried to solve the problem, we paid money, but more importantly, we tried to root out the problem in our organization. We established a protocol, how we deal with our contacts with public officers. We have 4 eyes principle now when we have such contacts. We kicked out all the people involved in the past in these problems. And if in that case, the government organizing the procurement process has sufficient trust in this company that it has bettered its life, then it's te absolvo, and you may take part in the procedure. So that's the way how we try to. But it's not perfect. But at least it's a preventive way, which we managed with it. We managed, yes, we managed.
Thank you so much, Chris. And the last question from Ms. Mande is how people can do claim on environmental claim. Maybe it is related to infrastructure, for example. Okay. Okay, so maybe it is about ombudsman in general, in public services, and do people can make environmental claim, right? Oh, just a complaint. Okay. So maybe just like, maybe because there is an ombudsman and there is also the public procurement ombudsman, right? Okay.
So what I understand your question that maybe it's not only companies who are interested in obtaining the contract that would like to complain, but maybe it's also people like you and me, the public at large, who would like to complain when something goes wrong in a public procurement process, which is a good question, because as I've shown you, the objectives of public procurement and the interests involved in public procurement, they are not only about this crazy internal market in Europe, they are also about other interests, value for money, sustainability, social responsible procurement. So if a government decides to procure a construction project or goods and services on the market, which the public at large thinks that's not a good idea or you're doing it wrong, how can they complain and how can they complain? They cannot complain before the public procurement ombudsman, which I explained. When I was chairman of the PPO, I once had a complaint from somebody else than the suppliers that are interested in the contract. There was a project in Amsterdam where the municipality of Amsterdam, they wanted a monument in the city. So they procured goods and services, construction services, an architect, etc. But they did in a way that was perhaps a violation of the public procurement principles. There was a group of inhabitants of the municipality in Amsterdam living in the area where the monument would be erected. And they said, we don't want that monument in our backyard because it's all trees have to be cut, it's going to block our... Then we had to say, and courts would do the same, the rules on public procurement are not to protect that interest, they are to protect other interests. So courts and the PPO would probably say, if the interest that is violated is not an interest that is covered under the Public Procurement Act, you cannot complain, you cannot sue. That being said, we have other mechanisms in the Netherlands that can enable the public at large to come forward when they think when they think this procurement is outrageous, it's not in the public interest. They could go to the general ombudsman, so not the procurement ombudsman, but we also have a general ombudsman in the Netherlands. But more effective ways nowadays in the Netherlands is to address politicians, journalists, etc., make a lot of fuss in the media, put pressure on politicians in order to ask attention for the fact that the government is doing something which is not in the public interest. And of course, if the government violates other rules than public procurement rules, the public at large can of course sue the government before the court. So environmental rules or planning law, that's obvious. But that was not the situation in the example I just gave about the monument.
Okay. Okay. Thank you so much, Chris. To conclude, because the PPO is to uphold the Public Procurement Act, so there are going to be other ways if people want to sue the said projects. Okay. Okay. It seems that the participants shows a very great interest to the topic, and sure there are some issues, okay, or other questions that cannot be answered today. For example, as Chris stated before, the state involvement is different between Indonesia and in the Netherlands, and we can put it on another discussion. But due to time constraint, I am regret that I must close the Q&A session. Okay, Thank you, Mas Rico and Prof. Chris, for being our speaker today, and also thank you all of the participants for participating in our discussion today. So, may I close this seminar? Yeah, of course. Okay. So, goodbye and thank you.